They are going to assert the proposition, I just read it, that a marijuana dab somehow caused this acute liver failure.
I don't know why people seem to not care about this case, but we're going to call it. Please go on the record. It's 9 a.m., the time that was supposed to be for everyone to be here to commence with today's motions, part of a special setting for multi-day motions, case 831543. Counsel for plaintiffs, whoever's chose to be here on time, would you like to make your appearances?
Of course, Your Honor. Good morning. Teddy Parker on behalf.
Okay, excuse me. Whoever's got.
That was
Okay.
I was
yeah.
just said including it out, Your Honor.
No worries. Let's get. Okay, appearance, please, Mr. Parker.
Yes, Your Honor. Again, Teddy Parker on behalf of the plaintiffs.
Okay. I don't have anybody else on behalf of plaintiff.
Yes, Your Honor. Mr.
Nobody's here, right?
He's here. He's not here, but he was just he walked up the elevator, came up the elevator with me.
Okay, counsels. Nobody asked for any, right?
So I don't know.
We've got a lot to go through, right? So multi-days, remember you even had me not finish up a trial so that we can get you all started today at 9 a.m. So
Absolutely, Your Honor.
you can appreciate. Counsel for defense, who do I have here for counsel for defense, please?
Good morning, Your Honor. Joul Odou and Matthew Kaufmann. Mr. Hoffman is remote for the real water defendants. In addition, present in court and also co-counsel is Eric Freeman. Good morning.
Okay, on behalf of ETT, Terrible Herbst, please.
Good morning, Your Honor. Valerie Rojas on behalf of Terrible Herbst. Along with me is John Thomasik.
Okay, and with regards to real water, need to circle back to. Okay, please, thank you so much, appreciate it. You don't mean Real Water Tennessee, right? When you say Real Water entities.
Real Water Tennessee has been dismissed. I believe that has been entered.
Okay, that's what just when you say Real Water, just for you all, the clarity of record, since that was clear articulated. Okay, Mr. Pepperman, you're late. Would you like to make an appearance?
Yes, Your Honor. Eric Pepperman on behalf of plaintiffs.
Is there anybody else who needs to make an appearance? Nope. Okay. So I understand, as you all know, and we gave you a nice reminder copies, right, on each of the council's tables, right? Each party has 5 to 7 minutes pursuant to the court's right order on December 6th, because you all chose not to provide anything despite being asked. Well, first off, it's on the court's website. Easy enough. Didn't do that. Court reminded you multiple times in open court. Still didn't do that. Then the court sent you a reminder email on the 1st. Still didn't do that. Then the court sent another reminder email on the 4th. Still didn't do that. So by the 6th at 4:20, this court had to make the appropriate assumption that you all did not need more than the standard time. The standard time being 5 to 7 or 5 to 10 minutes at most. I'll give you 10 minutes because it seems to me that at least that's written somewhere. So I'll give the 10 minutes. So you know you have 10 minutes per side per motion if you filed either a substantive motion, a substantive opposition, or a substantive joinder. And that means you need to reserve time if you want a rebuttal with regards to said initial timeframes. Okay? I understand one of the council needs to go next door, so we're not going to address the other issues at this juncture. We're going to just get started with motion practice, and we'll get going through everything. Appreciate it. Thank you so very much.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, so first motion we're calling is document 533, plaintiff's motion for summary judgment number 1, that's plaintiff's claims for strict product liability against Real Water and Terrible Herbst. In order to address that motion, this court needs to have a question answered, because in the intervening time between when the motion was initially filed, there was a stipulation entered into. So what this court needs to know for purposes of this motion and probably some other motions as well is I need to know the breadth and extent of the actual stipulation. Does the stipulation specifically cover just the parties so that it is to the plaintiffs, or does it cover that it includes the 5-gallon jugs and anything that was distributed to any other entity? Or does it cover a specific time period, etc.? So can I please get clarification from whoever's appropriate on behalf of Real Water? What was the scope of that? Because as you can appreciate, it impacts several motions, including the present motion for partial summary judgments. So who's going to address that, please?
Yes, Your Honor. Joul Odou on behalf of Real Water Defenders, AffinityLifestyles.com, Inc. and Real Water Inc. Sorry, Your Honor. The door was locked when I tried to enter earlier.
No, it was open at 45, 15 minutes early for everyone to come in.
I don't know, Your Honor. I tried the door, it was locked. And then the
Quarter
marshal
till,
let me
I've been
in.
on the bench. Everybody ready for people to come in. Anyway, so counsel, go ahead.
So, Your Honor, if the court's referring to the liability stipulation. I believe the plaintiff still intended to proceed forward with this motion as to adulteration because it affects both Real Water Inc. and arguments to the jury as well as ETT1.
Okay, right, which is why this court needs the clarification, right?
Yes.
Does the liability stipulation say that there is hydrazine in all products by Real Water, regardless if it was a retail product, a
Yes.
5-jug product, and regardless as to timeframes? That might be broken down from a timeframe concept. That's why this court needs to know the answer. So the stipulation is every single bottle of water, regardless of size, regardless if it was retail or 5 jugs direct, it contained hydrazine. Is that correct? Is that
So to clarify the stipulation, the agreement is that Real Water is not arguing that the plaintiffs consumed real water with hydrazine in it, and that was the cause of their injuries, with the exception of Miriam Brody. To answer the court's question, the court's view of the stipulation was broader than that. That was every bottle.
It's not the court. I'm asking. That's why I'm asking as a question. I need to know what it is because of some of particularly the arguments raised by ETT Terrible Herbst, right?
Yes,
The distinction between a 5-gallon jug and a retail bottle. So I just need to know, is the statement by Real Water, everything that went out Real Water's door, regardless if it went 5 jugs or it went to retail, all of it
No.
had a chemical compound in it, or was it a not contesting liability specifically to certain plaintiffs? You understand the distinction to what the court's trying to ask, because I need to know it for purposes of the motions.
Yes, Your Honor. Not every 5-gallon jug contained hydrazine, and not every retail bottle contained hydrazine.
Okay.
Real Water's position is that the plaintiffs consumed real water that was inadvertently contaminated with hydrazine.
Each of the plaintiffs consumed real water which had hydrazine. Okay. Is there a time frame?
No, Your Honor, it's just as to these plaintiffs in this particular case. And in the case of Miriam Brody, the argument isn't that
Causation.
what she consumed, the argument is, did it cause her injuries?
Right. I understand that part. You understand why the court's asking the question, because ET&T, and I'm not jumping to the opposition yet, but I at least need to know if that's a moot point, because as you can appreciate, you all filed motions. There's been some changing landscape, and so I need to know if any of the changing landscape affected, well, specifically this first motion, and then it implies to other motions as well. Okay, I appreciate it. Thank you. Counsels for plaintiff, do you concur with that was the breadth?
Not necessarily, Your Honor. And
Oops, okay, then somebody's gonna have to provide me the document number so we can
I
print out
believe,
the actual document. Can someone give me a document number so we can print out that actual document of the 986 entries in this case? Let me let you speak, Mr. Parker. I'm sure somebody else can look that up while you're doing that.
sure, Your Honor, I would refer the court to our reply brief.
That's why I'm asking the question, because of,
Exactly. And Your Honor, I will tell you, after spending an inordinate amount of time preparing for this motion, I'll come to the podium.
right, and I don't want to get to the substance of the motion. I just
Okay,
need to
good.
know the breadth of that for purposes, if there's any binding agreement between the parties that's going to impact this motion, right? And realistically, I was trying to just be fair to Mr. Odou because I knew he needed to go next door. So if he had to answer that question first, that he could then go next door what he needed to do and take care of what he needed to do. That's always why I kind of did it a little out of order.
No, Your Honor, and I think that was an appropriate question. I think it tees up the motion perfectly. Mr. Odou's response to what I believe to be the court's question seemed to limit the impact of the agreement, Your Honor, or the concession made by Real Water. I think the court's question included the answer, actually. I think that the stipulation in terms of Hunwardsen is an indication, with the exception of plaintiff Brody, that every jug of water consumed by these plaintiffs and every retail bottle consumed by these plaintiffs contained hydrazine. And I believe Mr. Odou was correct in saying regardless of time period, because I know the court's looking at time periods because certain plaintiffs are within 18, 19, 2020. So I think that's the impact of the stipulation.
So what I'm going to do, since there seems to be a little difference of opinion, I'm just in your If you wish to address it in your oral argument on each particular motion, I'll address it then. I just wanted, we could have gotten a global clarity, I would have gotten a global clarity. And okey doke. So, as stated, so let's start the clock running. I called motion document 533, plaintiff's motion for summary judgment, document 1, the strict product liability against Real Water and Terrible Herbst. So, counsel for plaintiff, whoever's taking it, it's 9:10. You've got till 9:20 if you want it, but remember, if you need to reserve time for rebuttal, then feel free to do so, okay?
And Your Honor, my plan is to reserve the majority of my time for rebuttal because I think the briefs are more than adequate, certainly our brief and our reply brief.
Sure.
Your Honor, let me first start out by asking if the court has any particular questions given the enormity of the briefing in this case.
No, I have the enormity of the briefing in this case. Now, I will tell you there's going to be an issue raised when I get to the defense side of whether I can consider any of the exhibits in regards to their opposition because they failed to comply with EDCR 2.27, but that doesn't apply to you all, so feel free to move forward.
And Your Honor, I will say, because I know the court has had a rough time of this, partly based upon our responses.
I've had no rough time. This court is fully prepared. Now, what you all chose to provide the court to allow it to be prepared to make it as difficult as possible for certain things. Realistically, I'm not sure why people would do that, but that was you all's choice, and I'm saying you all in a general sense. I'm not calling out anyone. Some people gave the court information that made it a lot easier in an organized manner, as discussed on November 13th, starting around page 201. Other parties chose not to give it either timely or accurately, but realistically, I've read everything, so feel free to proceed.
Thank you, Your Honor. And when I said we may have made it more difficult, I think the plaintiffs attempted, if we did not fully comport with the court's request, I think we certainly came closer than any other party in this action. And I think for that reason, the court has agreed to hear our motions in advance of the other party's motions. For purposes of edification, Your Honor, this case involves the finding of hydrazine in the 3 concentrates tested by the FDA. And that was a part of the FDA's investigation that started after 5 children were determined to have acute liver failure, taken from hospitals here in Southern Nevada to the Children's Hospital in Utah, and they were all found to have consumed real water. And so, as a part of the Southern Nevada Health District, the FDA investigation, Your Honor, as well as the CDC, hydrazine was revealed in high concentrations in the E2 concentrate, which is used to make all of the retail bottles and all the home delivery 5-gallon jugs. So the question you asked, and why I thought it was so appropriate to tee up these motions, is because there's been, of all the tests performed, be it the FDA test on the concentrate, which is used to make all of the products, versus the Eurofins testing that was done at the behest of the defendants in this case, every test resulted in hydrazine being detected at some quantity. There were, of the 7 bottles, retail bottles tested, 5 of which were found to be at the reportable levels, 2 were not at the reportable levels, but they were all found to have hydrazine. And so when you ask Mr. Odou whether or not these bottles all had hydrazine, his comments seem to contradict the comments he made to the jury in the Gallagher case. And the stipulation is identical. So I would have expected that his response to you would have been identical. In our reply brief, page 4, lines 22 through 24, we have an excerpt from Mr. Odou's argument to the jury. And he says, as I stated when I started, there's no dispute that hydrazine does not belong in water. There's no dispute hydrazine made these plaintiffs sick. In fact, there's no dispute that the plaintiffs are entitled to compensation. The next excerpt says, I expect that the other parties may try to put words in our mouth. They don't need to do that. We'll tell you what happened. We'll tell you we screwed up. There was hydrazine in the water, okay? Those are his comments. And so his concession, his stipulation, his admission, Your Honor, all go to the fact that hydrazine was in the water consumed by these plaintiffs here, as well as in the Gallagher case, and there's been not a single test performed by real water or any other defendant showing that hydrazine was not in a single bottle. Not one. You won't hear throughout these arguments today, tomorrow, Friday, next week, however long they need to go, or in trial, that there's ever been a test by any defendant in this case where a bottle was found not to have hydrazine in it. And so I want you to hold the defendants to the standard in terms of the shifting of the burden on the motion for summary judgment to show some type of evidence, supportable, admissible evidence that hydrazine was not in the bottles of water sold by Real Water, Your Honor. Your Honor, what I would also suggest to you is that it appears, and this is not so much Real Water, but I believe it's Terribles. I'm going to refer to ET&T as just Terribles, if that's okay for the court.
That's fine.
And Terribles, who was not involved in the Gallagher case, seems to cherry pick comments and bits and pieces, trying to string together what I would consider to be a very weak and unsupported argument. Terribles does not have an epidemiologist who will say that these plaintiffs did not get or suffer acute liver injury based upon their consumption of Real Water, which contained hydrazine. They don't have a causation expert who will say it. So what they try to do is they try to find little words and pieces from Dr. Hudson to suggest that perhaps there was not a uniform quantity of hydrazine in each bottle. And we will admit the manufacturing process used by Real Water may not have been uniform, resulting in varying levels of hydrazine, but it all had hydrazine in it. And so, Your Honor, hydrazine, based upon the CFRs we cited, 21 CFR 117 and 21 CFR 129, says that a product that has a toxin or a poison is considered adulterated. The findings from the FDA and the CDC and the Southern Nevada Health District determined that this product was adulterated. And fortunately for us in Nevada, we have NRS 585, which also defines adulterated. And so, Your Honor, leaving time, of course, for rebuttal, I don't believe that there's any evidence that the defendants can provide to this court indicating that a single bottle or a single jug did not contain hydrazine in it, rendering all of their products adulterated, defective, and as a result, summary judgment should be granted.
Appreciate it. Thank you so much.
Thank you.
We showed you about 5 minutes because I didn't include my questions. So,
Perfect. Thank you, Your Honor.
okay.
Mr. Kaufmann will respond on behalf of Real Water and Affinity, Your Honor.
Is Real Water going next then? That's fine. So that's opposition was document 791. Go ahead, counsel, for Real Water.
Thank you, Your Honor. Matthew Kaufmann on behalf of the Real Water defendants. I will just kind of hit the high points since Your Honor's read the briefings. First, as you're aware, Real Water's conceded liability, and ultimately we feel that plaintiff's motion for summary judgment as to liability regarding Hartshorn, Hunwardsen, Schaefer, and Sosa is moot as to Real Water. We continue to dispute causation for Miriam Brody, and as we highlighted in our opposition, our opposition highlighted evidence from 3 people. One, Miss Brody's treating ER doctor, who believed their symptoms were related to her blood pressure. 2, our expert, Dr. Alcina, a liver transplant surgeon, who stated the records show no evidence of liver transplant of a liver injury. And 3, Dr. Hudson, plaintiff's own expert, who admitted during his deposition that there was no objective evidence of a liver injury for Miriam Brody. Plaintiff's reply failed to rebut or even respond to any of the evidence raised by Real Water in regard to Miriam Brody. And on those grounds, I believe that plaintiff's motion for summary judgment in regards to liability for Miss Brody should be denied. And now, unless Your Honor has some questions, I'd like to proceed on to our argument regarding adulteration.
Feel free.
Okay. Thank you, Your Honor. First, Real Water's opposition raised substantive and procedural argument issues with plaintiff's motion for summary judgment, and their reply simply dismissed our opposition as quote-unquote semantics. I immediately had a thought of my original first partner looking at me going, Matt, you're an attorney now. The words you even use matter. And here we're talking about a term of art. And it's a term of art, as Teddy noted, sorry, not Mr. Parker, apologies, noted that it's a term of art under both the Nevada statutes and the federal statutes. In terms of the Nevada statutes, plaintiff's motion cites several statutes, but provides no analysis as to how this applies or how any of these statutes actually that should be dismissed by the court. Setting aside the lack of argument, Nevada's definition. I'm sorry, Your Honor, are you saying something?
You were cutting in and out. I think when you're leaning back, we're not hearing you. So if you'd like to be heard, please get near a microphone and please ensure, okay? And while you're doing that, I'll remind people, I did ask you what was the document number of said stipulation. No one's given me a document number in this case yet for said stipulation, so.
Your Honor, the stipulation has not been formally documented and entered yet.
Okay. Do you understand why the court asked the question?
Yes, Your Honor.
How can I possibly move forward today when there is a purported document that impacts multiple motions that no one has even bothered to file in this case? That directly impacts the arguments, right? Which is why I asked you all, what's the document number? What's the scope of the stipulation? Because I couldn't read anything. Going through 896 entries multiple times, trying to look for it. The proverbial pig sniffing truffles, but there wasn't even a truffle to be found because it had not even been submitted. Then we went through the DC 31 inbox and looked completely all through there to see if there was anything, which there wasn't even anything submitted. So we checked to see if there was anything in error that maybe had been filed and not submitted. No, that didn't happen either. Then we looked for directly to see if it was emailed inadvertently. It wasn't there either. The hours and hours of wasted time. Counsel, how do you want this court to move forward on a motion when I don't even have a document that impacts this motion and many other motions that anybody even cared to submit to the court? What's the scope of what I'm supposed to be ruling on, folks, if I don't even have some purported stipulation? That's why I had to ask you. I thought somebody would point out when I asked you, Your Honor, we actually never filed it, right? But you all have different viewpoints, so we tried to see if maybe you had the exact same viewpoint so I could go from there. But realistically, how can I move forward on any of these motions, counsels, if you chose not to even file the stipulation that impacts the substance of everything? Yes, I'm going to continue your trial to a different date, folks, because... right? When you're asking the court to counsel, is there any reason why? Was computers completely lost on every single attorney's? Is there any good cause for not filing any said stipulation? Or is this probably coming as a surprise to certain lead counsel that the court was asking this in court today because maybe they didn't even know it wasn't filed, or maybe it did, I don't know.
Your Honor, I think and if I speak out of turn for Real Water, because I'm only speaking for plaintiff and perhaps the communications with Real Water's counsel, Mr. Odou. I believe your question, the first question you asked today crystallized the issue for us. I thought we were on the same page in terms of the stipulation, and I thought that was memorialized in the way they objected to or opposed our motion. They conceded on everything except Ms. Brody. I just confirmed with Mr. Odou. I think we are on the same page in terms of the admission in terms of Ms. Brody not being a part of this motion, but everyone else, all the other plaintiffs being a part of it. But your question was precise, and I answered it believing what I thought the stipulation resulted in, our agreement at least, resulted in. Mr. Odou was somewhat different, and the court pointed that out very early. I think that Mr. Odou and I should confer to see if we can bridge this gap really quickly, because I do want these motions to go forward, and we are prepared to go to trial, although it complicates the issue.
Counsel, you can appreciate, it's the essence of the issue, right?
It is.
It's the essence of what's going forward in the case. It's the essence of motions to bifurcate. It's the essence of the liability scope. It's the essence of ET&T's argument, right? Which is why the court phrased the question the way it did, okay? Trying to give you all the benefit of the doubt, like maybe you could say, you know, it was there. I mean, we spent hours, okay? Including the weekend and stuff, trying to find it. That's in addition to all the other challenges as a result of people not doing it. So you can appreciate, I'm gonna have to vacate your trial date. We're gonna have to find you a new trial date. And we're gonna, because I have to hear these motions, but I have to hear the motions in the context of knowing what's actually the scope. Are we talking about liability? What's the breadth of liability? What's the years of liability, right? It's a plaintiff by plaintiff situation. It's a retail versus, you know, the manufacturer.
Let me see if I can corral this a little, just a little. And I'm not, two things. I'd like to have a second just to speak to Mr. Odou and see if we can come to a full agreement on the scope.
Not only Mr. Odou, it impacts how people did their pleadings, right? It impacts the arguments from Terrible Herbst, right? Because their argument is, in essence, they weren't part, and I'm not going to say, I'm going to paraphrase certain parts of their opposition. I'm not taking any position, but at least it was asserted in the opposition that they didn't do the Eurofins testing, right? That was natural foods, that the alleged that only Hunwardsen applies to them, and Hunwardsen predated certain dates. They're also contending that it was not, and nothing has shown that in the retail bottle that came from them from Nevada Beverage actually was. All salient, I'm not saying, I don't know if they're accurate or not accurate, I haven't, right? But all salient points for purposes of not only this motion, but should this court bifurcate the trial, right? If you're going to bifurcate it because is there issues of liability, there's still negligence claims, et cetera, products liability, what's the scope with regards to that? All things that don't just magically appear on the day of trial, right?
Absolutely.
So you can appreciate that you'd have to have an agreement from everyone, right? And then you have to have an agreement that in no way impacts every single pleading that has already been filed before this court, and no one's modifying any said pleadings. And no, you can't file something at 7:04 the night before and think I can hear it unless in 1 day's notice with nobody getting an opportunity to be heard. But that's a different issue. We're not there yet. But you understand it impacts every single aspect of what this case is potentially going to trial. And it's not as if you all are telling me that there was any emergency or any reason why you didn't file it or even submit it, right? You're not saying, guess what, Your Honor, we submitted it to the court and the court didn't review it. You didn't even choose to submit it to the court. And so unless I have an agreement that it does not impact a single pleading and everything is as is, right, then that's the only way I can move forward on these motions, because if anyone's going to contend that the scope of that language is going to impact their arguments, you can understand from a due process standpoint, I'm going to have to take that into account and then address it how I need to address it. I'm not saying how I'll address it because I can't make advisory opinions. I don't make speculative opinions. I don't know what people are going to say.
Of course.
But you can appreciate, despite all the time spent on all of this, I couldn't find anything. That's why I asked you all for a document number right off the bat.
You did.
And, you know, I'm not sure how you can say, walk it through from a standpoint. You're asking this court to make a ruling. You know somebody's going to say, well, Your Honor, you couldn't have made that ruling because guess what? You didn't have the clarity of what the underlying agreement between the parties was in order to make that ruling. And my saying those words in and of itself, you know someone's going to quote that.
Well, Your
And that
Honor,
presents a challenge.
I agree that there's a challenge. The scope of the challenge, I think, is smaller than the court may appreciate right now, only because the stipulation was a right that Real Water and plaintiffs had the ability to enter into. Certainly the court would not disagree with that.
But there's no stipulation, counsel. There's not even
Understood.
anything on the record under EDCR 7.50. I've got nothing. I also
Understood.
went looking through records to all the hearings and things like that.
Well, Judge, you do have something because in each and every one of their oppositions, Terrible Herbst has referred to the stipulation that they're going to make. They have said dozens of times in the pleadings that you reviewed, in all the oppositions, in their motions even, they're going to stipulate the liability as to the 4 cases. Now, they are having a problem with the Brody case, and I don't really want to get into detail on the reasons of that, but it's a
And
different
they're having an
policy.
issue on the Hunwardsen case for ET&T Terrible Herbst, right?
Terrible Herbst has an issue Real Water doesn't have an issue,
Right.
Your Honor. So they've said over and over again in these oppositions, and you've read it. You've read it dozens of times that they're stipulating
I'm
to
quoting it,
liability.
aren't I? Yes.
Yeah, they're stipulating to liability and causation. Even if they stood up today and said they're not going to stipulate it, they're bound by what they've said in the pleadings to the court.
Counsel, which is why you can appreciate what this court is, right? The various questions I asked was to the years, the 5 gallons versus the distribution aspect. And a lot of my questions have been focused on the ETT component of it because they're not, well, first off, there is no stipulation. Okay, there's just nothing. There's nothing under EDCR 7.50. There's nothing in writing. There's been nothing submitted to the court, so there is no court order. Now, whether or not there is concessions in pleadings, I appreciate that might be subject to argument between you all and Real Water. But ETT, Terrible Herbst, is also a party to this litigation. They have made a lot of requests, right? Including, that's why this court focused its questions on the bifurcation aspect and this particular motion, okay? That's why I tried to get a clarity. If everyone was on the same page as to what the actual agreement was, then the court could move forward. But you heard 2 very different viewpoints earlier on. So if you're asking for a nice little 15-minute break for you all to discuss, we'll come back, then please do so,
That's
okay?
a great idea.
Thank you so very much. Appreciate it. Okay.
Your Honor, see, are the,
Hold on a
mics
second. We
on?
need, Mr. Kemp never made an appearance.
Okay.
Let's get on the record, and we need, Mr. Kemp never made an appearance earlier, and you started speaking, so give us a quick second to get on the record, and then if you wouldn't mind making your appearance, please.
Yes, Your Honor. Will Kemp for Kim Jones, bar number 1205 for plaintiffs.
Appreciate it, and that was,
Yes, just the gentleman.
is anybody else speaking who needs to make an appearance? Because a whole bunch of people came in late.
Apologize, Your Honor. Mark Love with Kaufmann Parnell, on behalf of Real Water.
Trevor Everett, Terrible Herbst, bar number 15036.
We can't hear you from way back there. Please come at least near some microphone, please.
Trevor Everett with Terrible Herbst, bar number 15036.
Okay, appreciate it.
Thank you.
Okay, has anybody come late remotely that needs to make an appearance? No, okay. I did not see you.
Sorry, apologies with my view.
We need you near a microphone. Same thing if you'd like to make an appearance, please.
Yes, Your Honor. Elaine Fresh, also for Real Water, bar number 9263.
Appreciate it. Thank you so very much. Okay. Mr. Parker, the parties had a chance to speak and
Yes.
come to a resolution by chance?
Yeah, we have, Your Honor. I think the
Okay.
confusion, unintentionally, was the way the question was phrased. Mr. Odou took the question as meaning every bottle of real water and every jug of real water ever created forever. And our combined opinion of the answer is every real water bottle and jug for these plaintiffs in this case contained hydrazine.
Is that a stipulation on the record under EDCR 7.50? And what is and I'm going to have to ask ETT's position because were they aware of said stipulation at the time they filed various pleadings in this case, which they're asking for certain things and made certain arguments? Well, I'm just giving you the heads up of the 2-pronger. Counsel for defense, go ahead, please.
Your Honor, thank you. Joul Odou on behalf of Real Water and Affinity. Mr. Parker is correct. I heard the court ask Real Water every bottle, everywhere, at any time, not the water consumed in this case. The stipulation is just to the water consumed in the plaintiffs in this case.
Okay, so can someone tell me what this purported stipulation is that I'm supposed to be taking into account in all these motions that have been filed, please?
It's the same position that we've taken in all of our motions.
Counsel, your motions are very, very different because your motions talk about specific to plaintiffs, not bottles, right?
Yes, Your Honor.
And there's not a distinction between jugs and retail bottles, which is highlighted by Terrible Herbst. So I need to know, is it
Yes.
to all jugs and retail bottles, just jugs, just retail bottles, both jugs and retail bottles, some other carve out, as far as time frame, because I need to address the arguments raised by Terrible Herbst.
I can even say it better. The water
Well,
consumed
I'm glad you
by
can,
the
please do.
plaintiffs.
Okay,
The water consumed by the plaintiffs had hydrazine in it, Your Honor.
Okay,
It's not every bottle ever made anywhere. It's the water in this case, whether it was 5-gallon water, liter, half liter. The water in this case consumed by these plaintiffs,
all water consumed by the plaintiffs?
by these plaintiffs,
By
Your
these
Honor.
plaintiffs, okay. So is that a stipulation that you all need to do EDCR 7.50, or what is that statement of you, counsel, meaning? Is it
We would-
binding on all these pleadings? I just need to know the scopes.
We would like to put it in writing and have it to the court first thing after lunch, so there is no continued confusion.
In Your Honor, it was our belief that there was no confusion. When I read the motions, the oppositions and the reply briefs, there appears to be no confusion in my mind as to the stipulation. I understand and appreciate
There
why.
is no stipulation, counsel. There's nothing been presented. There's no stipulation.
Understood, Your Honor. And that's why I said I appreciate the fact that there's not a written stipulation. We will have something to the court right after lunch. We'll get it done during lunch. The one point that I would like to make, Your Honor, hopefully this helps in guiding the court's analysis, factual analysis at least. I don't care if it was a 1 liter, a half liter, a 2 liter, a 5-gallon jug. It all came from the same concentrate. Every bit of it came from the same concentrate, and every test of the concentrate resulted in a finding of hydrazine.
Counsel,
And so-
I'm hearing what you're saying, but you understand that that's not a uniform opinion by all parties to this case, which is the only case before this court. This Terrible Herbst has raised arguments as far as a variety of arguments which they're going to articulate in their opposition when they have a chance to speak. So let me hear theirs, right? I'm hearing what your position is. I'm hearing what Real Water's position now is, okay? But that's why the court needs to know what rubric we're looking at so I can make reasoned rulings and whether or not there's bound admissions, etc. Okay, so, counsel for plaintiff, you've had way more than your 10 minutes. Counsel for Real Water, you were, I think, mostly done, but you were about to address the adulteration aspect when things kind of got, since you cut out, we were starting to address something else. Go ahead, please.
Your Honor, I was addressing adulteration. First, I think I'll move this up in my argument just to be brief. If Mr. Parker during his argument said the stipulation is fundamentally the same as the one in Gallagher, if that's the case, then plaintiff will be dismissing the negligence claims against my client, which makes the adulteration argument kind of moot because it's no longer a claim or defense in this case, is procedurally speaking.
Hence,
Um,
why the court was asking all these questions. I can't, if I don't have any basis to know what it is, that's why I was asking what's moot, what's actually before me. Okay.
I understand, Your Honor, and I share your confusion, and I think I understand.
It's not confusion. You all do not have any stipulation that says anything to this court, what is or is not actually before this court. This court has to make well-reasoned rulings based on the pleadings before me, which reference something that has never been filed, reference something that does not give any context or body to it. And so the court, in reading each of those, you all have not articulated as you need to do under the EDCR what your points and authorities are and your arguments and what actually is the scope of what this court needs to rule on, which is really the simple question is, what actually is before the court? Go ahead, please.
As to adulteration under, just substantively, adulteration under the NRS involves a quote-unquote added substance. And in this case, hydrazine is not an added substance. You'll hear testimony. It's an inadvertent byproduct of the manufacturing process. Second, the other part of the definition for the NRS is that it is, the quantity is below a level that would, quote, render it injurious to health, end quote. And as you'll hear from Terrible Herbst is taking that position, even though Real Water is not in this case. Finally, the plaintiffs rely on the consent decree for evidence that Real Water is adulterated. However, they don't discuss the fact that this describes procedural adulteration, i.e., Real Water did not have the right record keeping. it's not chemical adulteration like the NRS definition. And I realize I'm moving kind of quickly. Furthermore, the consent decree is a settlement agreement. It's inadmissible. Plaintiffs are not opposing our motion to eliminate on that subject, and they have agreed with us on that. And I believe that's pretty much all I wanted to say, Your Honor. You seem to have a pretty good grasp of the briefings. And that's all. Thank you.
Appreciate it. Okay, Terrible Herbst, your turn. Go ahead, please.
Morning, Your Honor. Valerie Rojas for Terrible Herbst. Plaintiff's motion seeks to basically summarily try this case as to Terrible Herbst as well as the real water in moving for summary judgment on the product's liability claim. But plaintiffs bear the burden of proving not only that the retail bottles of real water were contaminated when they left the hands of Terrible Herbst, but also that that retail bottle, those specific bottles, were a substantial factor in causing Mr. Hunwardsen's liver injuries. And there's simply no evidence of that. As you heard this morning, and as you'll hear throughout the next couple of weeks, possibly, there was some Eurofins testing of Whole Foods retail bottles. Those retail bottles were manufactured in 2020 and 2021. What you will not hear is that any retail bottles from Terrible Herbst has been tested. Those retail bottles were pulled from the shelf the day after the recall, and there's been no testing.
Go ahead. No, I was going to politely remind people that if they're going to talk on somebody else's, we're not going to get a clear record because it's going to pick up you all talking. So either clip the thing so it doesn't do it. If you don't mind, thank you so much. Go ahead, counsel.
Sure. What we're left with is circumstantial evidence, Your Honor. And that circumstantial evidence weighs in favor, actually, of Terrible Herbst and against liability against Terrible Herbst. That circumstantial evidence shows that not all concentrates were made the same. Concentrates were made by different people over different periods of time. Real water began manufacturing in 2008. From 2008 to 2020, there were apparently no problems, at least no known problems. Mr. Hunwardsen himself consumed retail bottles of real water only from 2016 to mid-2018 without any problems. It was only when he began consuming home delivery real water that he now attributes some health issues. So even if real water wants to stipulate, that stipulation should not apply to Terrible Herbst. We're not a party to that stipulation.
How though? I mean, and that's, you can appreciate why the court started off the question that it did, right? It was highlighted in your briefing. But if they're saying from top down, which Mr. Odou can correct me if this is not the correct statement, but he said that's all these plaintiffs, right? All the water they drank, right? Was, what was your word, counsel?
Inadvertently contaminated with hydrazine.
There we go. Okay. Then how, if top down, they're conceding that, right? Are you saying something happened to the bottle once it hit Terrible Herbst shelves? I mean,
There are
the
many
outside fumes or something, you know what I mean? You understand what I'm saying? That's why, part of the reason why the court had to ask the question.
If you're, there's a potential for degradation of hydrazine, but I don't believe that stipulation comports with the evidence. It cannot. That would mean that every retail, if real water continues to do this throughout every trial, then every retailer is then bound by this stipulation, this supposed admission that's substantially prejudicial in a case where we're talking about products liability and there's joint and several liability. There's actual evidence to disprove that stipulation. I would like to see the stipulation to see how far it goes. My understanding was that it was going to be limited to a defective product causing the injuries. then Terrible Herbst would be left to argue, okay, it could have been the home delivery. And it may very well have been the home delivery bottles. If you look at the evidence, it all makes sense.
But I can't on summary. Remember, this is opposition to summary judgment. I limit to scope of what I can look at is the scope of what I can look at. That's why so you're saying that the court can't rule today on this motion? Are you saying that, I mean.
I don't believe it can. I don't believe it can until we see that stipulation and how far it's going to go in scope. We're obviously going to object to it, but I'm not sure how far that's going to go. We do have a motion for bifurcation on hand. Once we see that stipulation, we plan to file a motion and ask for an order shortening time. We filed a motion in limine number 1 to exclude the stipulation that we believed was going to be entered into based upon the Gallagher trial. We thought the idea was that they wanted to, just like the motion for summary judgment on issue preclusion, they were going to try to transfer that admission over here. And now it seems like we're going as even further with this proposed stipulation. I don't understand how the court can rule on this until we see that, until we get an opportunity to respond to what they're trying to say. If the stipulation is going to say Terrible Herbst retail bottles contained hydrazine, then that's a problem. There's just no evidence of that.
Okay. Well, feel free to finish your argument, counsel.
Sure. So what plaintiffs are left with is a Eurofins testing, which doesn't apply to Terrible Herbst. The FDA testing, which does not apply to Terrible Herbst. The FDA did not find any problems with retail bottles. Retail bottles were manufactured and made throughout the country for years without incident. It was only in 2019, potentially, that we see any problem, and that goes as to the home delivery. The plaintiff's own expert, Dr. Hudson, has acknowledged this and acknowledges that not all concentrates were made the same. It can't be. That's why we have no problems and we don't have major outbreaks throughout the country. If not all concentrates were made the same, then you cannot assume that every retail bottle sold by Terrible Herbst contained hydrazine. Thank you, Your Honor.
Appreciate it. Okay. Counsel for plaintiffs. Final word, and you know I'm going to ask you, what's it? One side telling me because of a stipulation that I've never seen now includes a release of claims, and so certain of your summary judgment doesn't apply here today because it's covered under the stipulation. I have the other one saying that they're going to object to the stipulation that they have never seen because it potentially can bind them, and they haven't had a chance to actually see it and actually respond to it. Well, counsel, please let the court know what's actually before the court from the plaintiff's position.
And Your Honor, I will try to unmurky what I believe to be very clear, clean water. And I think
counsel would love you to take that stipulation.
No, not real water being clean water.
No worries, go ahead, please.
The water that's been murkied by Terrible's counsel. Your Honor, let's first address what Mr. Hoffman said. And I don't mind you calling me Teddy, by the way, Matt. He's correct. In Gallagher, ultimately, as the motions and limine played out, Your Honor, there was an agreement by Real Water to stipulate to the causation, liability and causation. And we ultimately withdrew or dismissed all of our negligence claims. That is true. So I want to put that out there. And that's our intention as well. Our intention is to dismiss our negligence claims. And that's why you hear all of the arguments we're making are strict liability claims. But
as to Brody as well?
As to Brody, I think we may be working out a deal to even address Brody. But it's not in front of you right now. I don't want to complicate the discussion
I've got a summary judgment that I have to rule, right?
Right, your summary judgment. And I agree with Matt on this as well. Mr. Hoffman as well, or Real Water as well. Our motion was, I would say, was teed up to address everyone with the exception of Brody because we thought we had reached an agreement with Real Water on all of these issues. And so, with the exception of Brody. And Mr. Odou and I spoke about Brody today, this morning, just to make this a cleaner argument for the court and a cleaner motion for the court. Now, what I will tell you, Your Honor, and this is where I disagree with with Real Water's understanding of what adulterated means. NRS 585-300, Your Honor, defines adulterated differently than Mr. Kaufmann says. It's 588-300 says, a good shall be deemed to be adulterated if it bears or contains a poisonous or deleterious substance which may render it injurious to the health of others. That's it. I don't read the whole thing, but that's what it says. Certainly, every expert that has addressed this issue has found that hydrazine is a toxin and it could result in acute liver failure, which it did in these plaintiffs. And Real Water has now clarified the stipulation or concession, which you'll see on your desk after lunch.
But they haven't as far as the negligence claims, right?
We're going to dismiss our negligence claim, Sean. And we'll, if
So
you like.
which part of, I mean, you understand, I'm going to have to deny this without prejudice because there's just no actual agreed upon landscape of what this court is actually ruling on. Because I have objections to a purported stipulation that somehow modifies this motion, but no one's seen them.
I don't think it modifies the motion, Your Honor. And let me tell you why I believe it does not.
Okay.
The arguments, and I want you to start fresh in terms of what the rule says, Rule 56 says. Once we've put together evidence and provided court with admissible evidence as to why this product was defective, why this product caused the acute liver failures in these plaintiffs, it was incumbent upon the defendants to come back with something, the burden shifts, to show through admissible evidence why this motion should be denied. Now, you've heard some argument from Terribles, but you've not been referred to a single document, not a single deposition, not a single test result that says otherwise, that a bottle was tested that did not have hydrazine in it, or a jug was tested that did not have hydrazine in it, or that they have an epidemiologist who says these injuries were not caused by hydrazine, or a causation expert. You didn't hear any of that because all they have is argument. Your Honor, we've actually given you Dr. Hudson's report, Dr. Najim's report, our analytical toxicology report. We've given you all of those things, and you have the concession now by the manufacturer that their product was defective. That's what you have in terms of evidence. What Terribles has said in an attempt to murky the water is, well, they tested, Eurofins testing of the 7 retail bottles was of Whole Foods bottles. That's not true. That's just completely a falsehood. The bottles tested came from the warehouse. The warehouse was a warehouse of the products created by Real Water. That testing was done in accordance with a protocol approved by the special master and the court. That bottle didn't have Terribles on it. It didn't have Whole Foods on it. It was a representative bottle from Real Water. So where is the evidence contradicting the motion, Your Honor? Have you certainly, and I'm saying this rhetorically, Your Honor, but certainly Terribles hasn't given you anything to show that not any of their bottles, they didn't take it upon themselves to test their own bottles on their shelves, didn't have hydrazine in it. You have just the opposite. Every test, every concentrate, every bottle had hydrazine in it. And for these plaintiffs, in this case, Real Water has agreed to that. So I don't see, Your Honor, under the rule, how the court can deny the motion. The other thing I would point out, Your Honor, we're not aware of any motion for bifurcation that's still pending before this court. Bifurcation was brought up when the issue of the claim preclusion arguments were being heard. And I believe it was Nevada Beverage that was originally arguing that point of bifurcation. But I don't believe the court has a bifurcation motion in front of it.
December 1st letter from the Kemp Jones firm says there is one for document 592.
Now, I don't know of any bifurcation that involves Terribles,
Motion for a separate
Real
trial.
Water, or us.
Well, you all still put that on the list for the court to
No,
hear.
Your Honor, that may be a phased issue with these third-party claims, but not in terms of these parties here, Real Water, Terribles, and the plaintiffs.
That's correct, Your Honor. That was a motion filed by UNFI for a separate trial on its third-party claims against Real Water.
So one horse, one rider, please.
I
I mean,
apologize.
Well, I'm glad he's agreeing with me, but Your Honor, that's the case. There is no motion for bifurcation filed by Terribles, none by Real Water, and none by the plaintiffs. So that's not before the court. So I want the court to take that off the shelf in terms of a consideration for purposes of this motion. And Your Honor, you're familiar with the Mapes Hotel case, so I won't spend a lot of time, but a distributor, seller, reseller of a defective product is strictly liable, as would be the manufacturer of that product. So I don't want the court to allow what I would consider unsupported arguments of counsel to turn Rule 56 up on its head. We presented evidence in support of the motion. Terribles has presented no evidence, none. Not a single test result, not a single expert, nothing. And so I don't know how the court could deny the motion. Now, I see the court's concerned procedurally with the scope of originally the scope of the stipulation, but that's been cleared up, and you'll see it memorialized in writing. So if anything, if the court would like to hold this in abeyance until you get that stip in front of you, I understand that, to make sure that the parties' pronouncements to the court are consistent with the written document.
I asked you all if you wanted to make a stipulation on GDCR 7.50, and I was told no.
No, we're willing to do it now, Your Honor. We're
As to
willing.
the scope of what everything was, I was told you all wanted to put it in writing.
No,
so
we are doing that for purposes of having something in writing. But we agree right now, today, this morning, of the scope of that agreement. And we believe it's borne out in our briefing, Your Honor. I know it's not specifically alluded to in the form of a document.
It's argument, counsel, you know that.
I-
You know
Your
the
Honor,
court,
I
right? I
agree.
have to look at evidence. 56
I
is
agree.
clear on that.
But for purposes of making a record in accordance with the rule, Your Honor, on behalf of the plaintiff, we're doing that. And I believe on behalf of Real Water, Mr. Odou is doing that.
And I need to hear it from Mr. Odou if you're doing it under,
Yes, Your Honor, there's a draft written document that we have a minor change. We're going to email it back to them and try and get it printed and signed.
what actually is the scope? Are you saying it impacts Terrible Herbst?
Yes, Your Honor.
Does Real Water's
The scope has
stipulation
been,
impact
has
Terrible
been
Herbst?
accurately described by Mr. Parker, and we have reached an agreement on the scope. It is as to the water consumed by the plaintiffs. I understand the court drew a distinction between 5 gallon and retail.
I'm not
We're
trying to
not-
figure out, I'm asking if there is a
You had asked,
distinction.
I apologize.
I don't
Your
have
Honor.
anything. This beautiful crystal ball that my last extern gave me is absolutely beautiful, but it actually does not tell the future or read people's minds. So that's why I have to ask, right?
You do.
Because you may know what you're talking about, but unless you notify the court, either in court, right, EDCR 7.50, or in writing, courts don't, well, this court does not speculate, do advisory opinions, nor do I think I know everything, because I don't. I have to hear it from you all with regards to what is the scope of any purported stipulation, not just a reference, an argument that's phrased very differently depending on who's saying it and what pleading, and what stage of said pleading.
I apologize, Your Honor.
Not a problem. I'm saying, so is it your stipulation, you're saying binds Terrible Herbst?
Is our stipulation binding Terrible? Your Honor, I think Terrible Herbst has to answer that question. I don't believe Real Water has a position on that at all. Our stipulation binds Real Water.
Okay. But are you contending that any bottle that would have gone to Terrible Herbst for purposes of the plaintiffs in this case, and this is the only case before this court at this particular juncture, taking no position on any other case,
Actually, yes, we have conceded that any bottle consumed by any plaintiff in this case, regardless of where they purchased it, was inadvertently contaminated with hydrazine.
and with regards to Mr. Hunwardsen, is there an additional aspect of your stipulation that impacts him?
I
Because
do
you
not
have a
believe so. He
causation
consent-
concept, right? You have a causation concept. What you said with all plaintiffs other than Brody. So does your stipulation
Miss-
cover Mr. Hunwardsen as well?
Let me say in the affirmative. We have reached an agreement that we are not contesting that Mr. Hunwardsen consumed both 5 gallon and retail water inadvertently contaminated with hydrazine.
Okay. is there, because remember, this motion is seeking further than just the concept of consumption. Is there a stipulation that the amount of hydrazine, or however you all are phrasing it, in said water, and I have to ask about Hunwardsen because that's where AT&T Terrible Herbst is raising a different issue. I don't have anybody else raising it for the other plaintiffs right now other than your Brody carve-out, that level caused his damages?
Yes, the real water caused Mr. Hunwardsen's damages. We disagree that it is adulterated. We believe that has a specific meaning in the law.
Okay.
And it may become moot later, but we understand the court's question. We have a written stipulation between the plaintiff and real water that we might even be able to get printed out and signed.
Okay, so moving target, trying to make sure we got the right landscape. So, counsel for plaintiff, did you have an opportunity to finish your supposed 10 minutes?
Yes, Your Honor, unless the court has any other questions, I believe, given what Mr. Joul has said now, I don't believe there's any issue as to causation for the plaintiff, consumption, the inclusion of inadvertently hydrazine, and given certainly the court's familiar with the Mapes case, as well as the Riviera Phillips Moore's case, which we cited in our reply brief, which holds a retailer, a reseller, or a seller or distributor strictly liable under these conditions, Your Honor.
Well, you know I'm going to have to ask a question. My question is going to need to be,
Yes, Your Honor.
we've got to circle back to Terrible Herbst, right?
Absolutely.
They have stated that they didn't, and I'm paraphrasing, she may have said it more articulate, but right now, that they were not aware or had the benefit of knowing the full scope, because there is no written stipulation, right? In fact, nothing had been circulated to them with regards to Hunwardsen, right? So you raised certain cases in your reply brief that were not in your moving papers.
In our moving papers, Your Honor,
Right, where I'm going with the question is,
Go ahead.
do I need to defer with regards to Terrible Herbst for today and request some supplemental briefing about whether or not the stipulation that nobody's yet seen, but you all have articulated, at least in part, verbally within the last few moments, whether or not that can bind Terrible Herbst for purposes of your motion for summary judgment, since that's part of the prong of how you're basing your summary judgment, right? So do I need supplemental briefing on that, or are you saying I can rule today on that?
I believe you can rule today, but let me tell you why precisely, Your Honor.
Sure.
You know, I'm a paper person, so
No worries, I'm relying on papers and documents too. So.
And so, Your Honor, we did cite the Mapes case in our brief, our initial brief. So that's nothing new, and it shouldn't be nothing new to any attorney practicing in this area in
The concept, yeah.
Yeah.
Of course. I mean,
Come on. So we agree there, Your Honor. I mean, that's a 1970 case. So certainly, if you're practicing in this arena, in this part of the law, you should know Mapes, and you should know the cases we've cited.
where really the court's focus of the question is, right, is whether you want to call it equitable, whether you want to call it fair, whether you want to call it due process, right, is at least it's been contended by counsel for Terrible Herbst that if not seeing a stipulation, which everyone admits was not circulated to them, never provided to the court, so there's nothing that actually says what the right written agreement is, right, and it's been articulated in court, at least in part, and that itself is developed based on different phrasing, right, of different arguments, is can the court rule today on utilizing the stipulation which Real Waters agreed to be bound to, but utilizing that conceptual stipulation to impact Terrible Herbst, or do I need supplemental briefing on that in fairness to the parties so that the court gets the benefit of both sides' position on that? And here I'm using both sides between Terrible Herbst and plaintiffs.
So let me address it this way, and then I'll answer the question more directly at the end, Your Honor. I have realized through the review of the motions in limine filed by Terribles that they paid a lot of attention, Terrible's paid a lot of attention to the Gallagher case, because the motions talk about things that were done in Gallagher. I also realized that either they had the transcripts or they had someone listening in, but the stipulation that Real Water entered into in that case, the written document came well after the pretrial motion practice, as this one is actually ahead of the game in Hunwardsen compared to Gallagher.
Maybe October 4th might have been the date of the Gallagher one?
Thank you.
Maybe?
Maybe. So,
Maybe?
but the point is, Your Honor, the briefing and that trial practice in Gallagher and obviously the transcripts that were read by Terrible's counsel reflect the exact same thing that we're doing here. In that case, Real Water conceded as to those plaintiffs. And that's all Real Water is doing in terms of these plaintiffs. So I believe if I was sitting in Terrible's seat, what I would do is argue for some time. But I don't believe this court should do anything that would jeopardize the trial date. So I have to temper my response to the court. So this is what I would suggest, Your Honor. Although I believe that this stipulation is no different than the one we entered into Gallagher for those 7
We're
plaintiffs.
not a party in Gallagher, correct?
They were not a party, but they've been a party to the consolidated proceedings, and they had the benefit.
Coordinated for discovery other than just, okay, counsel,
I like it.
Language matters, right?
It
'Cause
does, words matter. And they were also the beneficiary of obviously those transcripts that they sent through the trials. But in addition to that, all of the briefing, including the reply, talks about Real Water. So substantively, I don't see the disadvantage to them or to Terrible's counsel, given what has now been articulated on the record, which is consistent with what was done in Gallagher and was consistent on what the briefing and especially the opposition's reply briefs reflect. So I don't know how Terrible's can get up here today and say that they're not prepared. But if the court believes that they're not prepared and that there's certainly nothing in the law that they need to address, because the law is the law and we know what the cases say. A distributor is just as strictly liable. But if there's some facet of their opposition that would have changed because of how this agreement has now been described, which I don't see how it could be surprising, then, Your Honor, perhaps a day of additional briefing, and we can put this at the end of maybe Friday. But I would suggest, Your Honor, the benefit of having the motion for summary judgment heard first, and I appreciate the court allowing us to go first with this one, is that it will definitely shorten the remaining motions. And I thought that was the reason why the court put the dispositive motion ahead of the motions.
No, you all requested it, and plaintiffs actually gave me.
We did, but
a
you could have
copy
changed
and
your
a
mind. You
courtesy
could have
copy
changed
in
it around.
accordance with the rules that allowed this court to actually look at something.
Well, we try, Your Honor. We do
I
our
know,
best.
but I'm just saying, in fairness, if you all did it, then I could look at it. If you all don't provide me things that I can actually prepare for, then realistically.
Realistically, you don't have to consider any of the defendant's motions.
Well,
And Your Honor, we're not
no,
saying you
that's-
should.
I'm not saying that that's what the rules say. There's challenges on all their pleadings why they don't have
Exhibits.
exhibits numbered, but realistically, that's a separate challenge.
Yes, Your Honor.
You can
Yes, Your
appreciate I've read everything, it's just a matter, okay, so let's walk through, 1 second.
All right.
And I'm going to give Terrible Herbst 3 minutes to respond, because realistically, a lot of people have been talking about what their impact is, and in fairness, you're going to get last word in this supposed 10 minutes that's not gone on for an hour and a half. Councilman Terrible Herbst, if you want a few moments to just address whether I should rule today or not, right? Because the question becomes is Terrible Herbst impacted by the fact there's not a written memorialization or something clearly stated on the record prior to today as to any agreement between plaintiffs and Real Water versus, yes, they did attach some of the various stipulations to some of their pleading. Yes, there's been some general references, but so, counsel, are you all prejudiced and requesting anything, or you're fine with the court ruling today? Let's hear what your position is, please.
Thank you, Your Honor. We are requesting, excuse me, additional time to address the stipulation as well as the impact of that stipulation on this motion and on the trial. Your Honor may
Through in
recall,
trial.
Your Honor may recall that there were 2 prior motions to bifurcate in this case early on that were
And the court
denied.
already ruled on those without prejudice, and no one filed a new one other than the third party one, which is number 7 on the potential list, which is not being heard because.
Correct. Those were denied without prejudice. I didn't say there was one on calendar. I said we will be filing one, in addition to objecting to whatever stipulation. And it's that stipulation. There was no retail defendant in the Gallagher case. There was a distributor who eventually settled, but there was no retailer like Terrible Herbst, Whole Foods.
Depends on which stage of Gallagher, right?
There was UNFI, which was a distributor.
This only case before this court is Hunwardsen.
Right, I
At this
understand.
particular moment, I'm
I
not taking
understand.
any
The
position
counsel
on any
raised-
of the other cases that are currently before me, including one case which may or may not be before me, but nobody's letting me know whether it is or is not before me, but it's okay. We're not at that case. We're at this case, Hunwardsen. So your request is what? Can you clarify specifically what your request is so I can address it, please?
We would request additional time to receive the stipulation and to supplement our briefing in opposition to this motion based upon that stipulation, as well as an opportunity to file a motion to bifurcate. I would agree with counsel that perhaps by Friday afternoon, or if that's not what he was suggesting, that's what we would request, assuming that we get the stipulation today.
Well, it has to be circulated to you before it gets provided to the court in accordance with the rules. So one would hope that somebody's going to send it your way, and I'm sure all these wonderful officers of the court are going to ensure it gets sent your way before it gets submitted to the court. So that part shouldn't be an issue because it'll get rejected if it's not.
Okay.
It has to. Okay. Here's what the court's going to do. As lovely as the last hour and a half has been, thank you so much for the wonderful 10 minutes of argument on this particular motion. But the fairness aspect here is, in fairness, the parties who wish to enter into a stipulation could have easily have done so. The fact that you all are setting forth that much of it's already drafted and written and already been done before really highlights the fact that it could have been done prior to mentioning certain aspects for purposes only when the court brought to the attention that there was no stipulation, yet there's references to stipulation. So realistically, I can't bind a party in their opposition to somehow respond to everything when they don't have the benefit of the quote, everything that they need to respond to. So you do have a trial starting January 16th, at least as of this moment you do. And so I think the fair thing to do is to defer ruling on the document 533 plaintiff's motion for summary judgment. I'm going to provide each side simultaneous. Anybody who wants simultaneous, I'm going to do Friday at noon. Okay? I'm putting this on for next Monday or Tuesday, depending on where I am with regards to some of the other motions. Okay? So if I say Friday at noon, okay, so it'll be early next week. You'll find out when we get closer to Friday where we're going to put it, depending on where we are, different things. If I say Friday at noon simultaneous, if you choose not to file a brief, then I take what I currently have, and I have no briefs whatsoever. I might just rule on what I've got. If I have one brief, I'll consider one brief. If I have two briefs, I'll consider two briefs. If I have three briefs, I'm going to consider three briefs. There's not going to be any extension of page limits on said briefs, folks, okay? This is really a discrete issue. This is not an opportunity, please, to re-argue any of the substantive aspects in the underlying motions, oppositions, or reply. It's on the very discrete issue with regards to Terrible Herbst. And it's, if A, I guess you can phrase it how you wish to do it, but conceptually B, is Terrible Herbst bound by said stipulation or not? What is the impact, if any, on each party's position, right, of what Terrible Herbst would have an impact? And then if there is a modification of anything from the opposition that needed to be addressed, I think that's appropriate to do. And I appreciate, since I'm doing it simultaneous, one party may say, well, why don't they get a reply to that? Because realistically, you created the issue, okay? And so they've already discussed here in open court what they thought their positions are, so I think that gives everyone appropriate notice to do so. to respond if you wish to do. So I think simultaneous balances the court's administrative function. It balances the fact of giving an opportunity to respond by getting an extra pleading and supplement for the court to evaluate. Gives everyone appropriate time to do so with regards to the time periods you all created. Because remember, we're hearing these, your motion deadlines were your motion deadlines because several people asked this court right at the time to not do things when they were in the midst of the Gallagher trial. So we are at the various dates, and I appreciate some people may not have been, but that just meant you had extra time. So I don't see any negative impact there. With that being said, we are going to move on to number 2. So Noon, please get us a courtesy copy. If you don't give us a courtesy copy, then your document will not exist. If your courtesy copy is not in compliance with the rules, it will not exist. I think that is fair because this court has said that so many times, and I don't need to say it. It's in the rules. Okay, thank you so very much. I do appreciate it. We're now going to try and move to number 2. Number 2 is motion for summary judgment that all plaintiffs' medical expenses to treat liver injury are deemed reasonable, necessary, and customary based upon the lack of defense expert testimony. Counsel, a real 10 minutes on this one. Who's taking it on the D table?
Yes, Your Honor.
I'm on the P table. I didn't mean the D table. My apologies. I'll gone back and forth.
There's a mic over there if you want.
So you can speak from there. You can sit down. You can stand up. You can go to podium wherever you want. But your 10 minutes is starting. So feel free to pick where you'd like to go from.
Thank you, Your Honor. I think this will be a short one. I'll reserve.
Isn't that what I was promised last time?
I know. I famous statements, but we move for summary judgment on the the fact that the plaintiff's past medical bills were reasonable, necessary, and customary in terms of their amounts. Terrible Herbst did, with respect to Myles Hunwardsen's past medical bills, did not oppose the request. Real Water opposed the request as to plaintiffs Sosa and Hartshorn. In the reply, they only challenged a couple of the charges as being not related, and to avoid any dispute and to save time, we agreed to amend the amounts to remove those charges. The only thing that's really in dispute in this motion is the amount of plaintiff Brody's past medical expenses. Real Water opposes the request as to Ms. Brody in the entire amount, but the argument isn't that the charges were unreasonable or not customary for what the services were that were provided. The only argument is that Real Water didn't cause the injury, so she shouldn't recover any past medical damages. I don't think that's what we're asking the court to decide on this motion. I think that we understand their dispute, assuming that dispute goes to the jury. If the jury decides that Ms. Brody's injuries are caused by Real Water, then we think that the past medical bills that she is claiming are reasonable and customary for those services. If the jury determines that the Real Water did not cause Ms. Brody's injury, then we don't dispute that she's not entitled to recover any of those past medical.
Is there a third option in your motion? Because it was unclear. If the jury were to find that part, right, that it's not 0 or 100%, that there's some percentage of things in light of the assertions of the various comorbidities raised in the opposition. Is that part of your summary judgment? It's all or nothing, or is there a third option in your summary judgment?
No, it's not our position that it's all or nothing. In the event that Real Water was to challenge that only part of the bills were caused by Real Water, or the jury were to find that, then whatever those bills the jury find were caused, we just want to avoid any issue that those bills were not reasonable or customary in light of the cost of the services. So that's the narrow issue of the motion. I don't think that there's really a meaningful dispute, so we would ask the court to grant the motion under those circumstances, that the past medical bills as agreed to between Real Water, Terrible Herbst, and plaintiffs were reasonable and customary in terms of their amounts.
with the modifications set forth, with the reductions of two of the plaintiffs and then the issue on Brody. Is that correct?
Yes, Your Honor, we agree on the amounts.
Okay, appreciate it. Thanks. I'm going to go to Terrible Herbst first because yours seems more narrow, and I'm really going to ask you, it appears that you say on page 1, line 18, that you don't dispute the amount, although you reserve your right on other arguments. So feel free if you need oral argument.
Sure. Yes, Your Honor. We do not dispute the past medical bills. We were reserving rights as to the future proposed medical expenses from plaintiffs' other experts. So counsel correctly stated there's no opposition to the past medical expenses.
678, 376, 17?
Yes.
Okay. Thank you so much. Real Water, who's taking it from Real Waters?
Good morning, Your Honor, Mark Love for Real Water. Real Water's not disputing
Can you hear, is a microphone nearby?
Oh, sorry.
Appreciate it. Yeah, we just need arm's reach, whoever's speaking. Go ahead, please.
I feel like I should do like a synopsis.
You can have it right below you. We just need about arm's reach. No worries.
Yeah, so as counsel for plaintiff pointed out, we're not disputing that the medical costs are reasonable. Our only dispute is on the Brody case. None of her medical costs were associated with any liver injury or injury related to drinking real water. And so we would dispute that those numbers should be stipulated to or come in. However, we are not disputing that the treatment that she received, which wasn't related to liver damage, was the costs were traditional, reasonable, and necessary.
So you concurring with Mr. Pepperman's statement that if there's a 0 on causation, and there's a 0 for, I'm not paraphrasing it correctly, please let me know, but if there's a 0 on causation, then there's a 0 on real water. If there's 100% on causation, then there's 100% subject to joint and, well, that's Brody, so it's not joint and several liability because you don't have that one here. Subject to any other agreements the court may not know about behind the scenes. It's 100% real water. If it's some percentage thereof, then the amount would be subject to liability for real water. Is that, Mr. Pepperman, is that in essence?
Yeah.
Yes, Your Honor. If there's no causation, there's no past medical damages. If there is causation, then the medical damages that she incurred are reasonable and customary. And
subject to what the jury says is the amount of causation, meaning if they parse it out, whatever hypothetical percentage they parse it out, anywhere from 1 to 99 to 99 to 1.
Yeah, I think if it would have to be a specific determination on.
That's called a jury verdict form, right? On a special.
If they don't find it's the cause, then the medical bills aren't recoverable. If they find that it is the cause of the medical bills and the services, the amounts are reasonable and customary. That's the narrow scope of the motion.
To the extent of what they find is causally related, right? So if they hypothetically say one surgery is and one surgery isn't, I understood you to be saying that the one surgery that is whatever the associated bill for hypothetical one surgery is causally subject to summary judgment, but that the other one wouldn't be, right?
Yes, Your Honor. We do not seek to preclude Real Water from challenging causation of any of the medical services that were provided. Should the jury find that there is causation for any of the medical services provided, we just ask for an order finding that those medical costs were reasonable and customary for the services provided.
Counsel, with that clarification?
I think we're all on the same page now at this point, Your Honor. I appreciate the court clarifying, but I think based on what the court described and what plaintiff counsel agreed to, I think we don't have a dispute on this.
Thank you. So we're treating this as unopposed, we're treating this as a stipulation, we're treating the court ruling on it. How are we treating that in light of the statements made by counsels in open court?
I can say
Granted.
based on I would ask for a ruling based on the parties' stipulations at the hearing, so that way we can make sure we agree on the terms of the proposed order that we submit.
That meets your needs, counsel for Real Water?
That's fine, Your Honor. No objection to that.
Does that meet your needs, counsel for Terrible Herbst?
Yes, Your Honor, no objection.
It is so ordered. And just please remind the court at the time when you all are doing your jury verdict form, right, if you need some special lines on those as a special interrogatory, right, to break things down. Okay?
Thank you, Your Honor.
It's ordered, taken care of. Perfect. Okay, thank you so very much. Now we're going on to document 661, which is plaintiff's motion eliminate number 28 to include Real Water, Tennessee, UNF. Oh, sorry, that one was withdrawn, was it not? I'm gonna read it, but I understand it's withdrawn. That's the reason why I'm reading it, so.
Sounds withdrawn, Your Honor.
Okay, then that's withdrawn, so then we're gonna go to document 596, plaintiff's motion eliminating number 1 to preclude defendants from offering highly speculative opinions that the THC dab caused the acute liver injury of Hunwardsen, the dirty dab theory. Positions thereto and replies thereto. Counsel, feel free to proceed. Go ahead.
Good morning, Your Honor. Your Honor, I know you've read this all, so I'll be very brief and focused. I'd like to start out with, just to show the court exactly the opinion that we're talking about. Shane, could you pop that up for me, please? Your Honor, this appears in the motion on page 16, lines 21 through 22. This is Dr. Atchison's opinion. Dr. Atchison is the expert retained by Terrible Herbst. No signal?
It just takes a second because you're switching over from having all the people that are on blue
Are you
jeans.
doing Dr. Parker?
Yes, please.
It's on Dr.
No worries.
I
Talk about
apologize, Your Honor.
document five, no worries, you're talking about document 596, your exhibits.
Your Honor, I can just read in the record what
That's fine.
I'm referring to. Okay, again, this is on page 16 of the initial motion, lines 21 through 22. This is Dr. Atchison's testimony at the deposition. Quote, so what I'm stating here is that there is a possibility that the THC dabs that Mr. Hunwardsen used had residual. It may have been pesticides. It may have been residual organic solvents. It may have been the way he was using it. I don't know. That's the opinion. That's the dirty dab theory. So what I want to focus on, and again, like I said, I know you've read the pleadings and you understand the Morsicata and the Williams cases, but I just want to focus on the speculation that's involved in this opinion and then the lack of science. Okay, let's start out with speculation. This is compound speculation. There's basically 5 layers of speculation here. He is speculating, first of all, that crops of marijuana grown in Nevada have this pesticide, which is paclobutrazol. That's the pesticide the only pesticide, the only thing by name they've identified. So he's speculating that happened here in Nevada in 2019, even though we've had a state law that outlaws that since 2014. No proof whatsoever that happened. Second, he's speculating that particular marijuana with paclobutrazol on it was used to make a marijuana dab. And then he's speculating that it wasn't tested. Under state law, you have to test each and every batch that's used to make marijuana dabs. In other words, you don't test just 1 out of 100. You test every single one. So they're speculating either that it was not appropriately tested or that the testing was somehow flawed. Now they're speculating that the particular dab in this case, the one that Mr. Hunwardsen used, had paclobutrazol on it. That's the 4th layer of speculation. And then finally, they speculate that there's enough paclobutrazol on it to cause acute liver failure from one single marijuana dab. So that is the layers and layers and layers of speculation that we contend are precluded by both Morsicata and Williams. And I would point out that if they really wanted to prove a case like this or offer evidence to the court, what they could have done is they could have subpoenaed the independent testing lab records that are filed with the state, and they could have found out if there was even one single product in the state that was ever made with paclobutrazol. They didn't do that. They can't even prove that. They could have found a rejection rate on these dabs, if there is such a thing, by these independent labs. They didn't do that, Your Honor. So instead of trying to develop concrete evidence that there's a potential problem, they just hypothesize that there's a problem. That's speculation. That's sheer speculation. Now, let's turn to the science. They are going to assert the proposition, I just read it to the jury, that a marijuana dab somehow caused this acute liver failure. Well, there is no scientific paper whatsoever that says that marijuana dabs or marijuana cause acute liver failure. The only paper that has cited is the one that we cited, which is by a gentleman named Raber. And what Raber did is he studied the California market between December 2012 and February 2013. Specifically, he took 57 concentrate samples from dabs made in the market there, and at that point in time it was illegal in California. So he is taking concentrate THC dabs made in the illegal market. And he found during his study that something like 7.57% had paclobutrazole in it. But, Your Honor, that is a vastly different situation. Those are THC dabs used with crops grown in the wild. And why is that important? That's important for two reasons. One, there's no regulation by the state of California or anyone else on what kind of pesticide you can use on that. And two, unlike crops grown in a grow house, you have the potential for overspray. In other words, the farmer next to wherever the marijuana crops were growing could be using this illegal pesticide, and it could somehow get on that. So you have that potential. But even under that scenario, even using illegal marijuana growers, he only found 7.57% of the paclobutrazole. So that is the scientific paper they rely on. Now, they also forget, and I'm moving over to the solvent thing, the science on the solvents. A solvent is a material that's used to somehow or another heat up the marijuana so it concentrates the THC. So there's different solvents used. Okay, so the theory here is, Dr. Atchison's theory is that when they were using a solvent to heat up the marijuana to make the concentrate, that somehow there was a residual of that solvent that got into the THC dab. Okay, that is the underlying theory. Well, the problem with that theory, and Raber, again, the only paper on this point, Raber specifically says that, is that you can make it either in what's called an open loop system or a closed loop system. An open loop system is what Raber was studying, which is people in their garages just heating it up and trying to concentrate the THC. That's an open loop. There's no control over where the solvents go and what happens to them. A closed loop system is what is required under Nevada law. Each and every dab made in Nevada is made by someone that's using a closed loop system. And what that means is that is it's a big machine. I can't remember what it costs, like $100,000. It's a very expensive machine. So, and the primary purpose of that machine is to prevent solvents, residual solvents, from going onto THC dabs. And Raber, in his paper, explicitly says that that machine stops residual solvents, okay? But if that's not enough, and again, this happened in 2019, so they're speculating that in 2019, somehow or another, a closed loop system wasn't used, even though it's required by law. They're speculating that there was residual solvents. Now, again, that gets us back to the independent testing. Under Nevada law, you have to have independent testing, as I've already said, of each and every THC dab. You're testing both for pesticides and also for residual solvents. So they are speculating, number one, that somehow or another, the closed loop system that the Raber paper says works to prevent residual solvent didn't work. Number two, that this dab either wasn't tested or the testing wasn't done properly, or that there was some kind of fraud on part of the testing laboratory. And then number three, that there's some sort of solvent on this dab. Now, it goes even further than that, because they have not even tied the solvents into acute liver failure. They can't say, oh, Judge, it's solvent A, B, or C, and that is a known solvent to cause acute liver failure in these dosages. So they speculate that there's a solvent on the dab. They speculate that it's a solvent such that can cause acute liver failure. They speculate that there's enough of that solvent to cause acute liver failure. And again, there's no evidence of this. They could have gone back, if they wanted to, and subpoenaed the state testing records from the independent laboratories. Wouldn't have taken that much, and they could have found out if there are any residual solvents present in the state of Nevada. There's no evidence whatsoever there are. There's only evidence from the Raber paper that people using this garage making process had some residual solvents. And there's not even evidence as to those garage people that those residual solvents cause acute liver failure. So this is a pretty speculative theory. I mean, like I've already said, there's 5 layers of speculation. There's no science behind it. And this is the kind of thing that should not go to the jury. I mean, we were actually the attorneys for both the Morsicato case, plaintiff's counsel for Morsicato, and the Williams case. And this is really similar to what happened in Morsicato, only worse, because at least in Morsicato, the defense doctor there had a list of possible causes that he was trying to rate, okay? He did have some evidence that those possible causes at least could potentially cause the injury in that case. In this case, there's absolutely no evidence, and like I've already said, it's based upon layer and layered speculation and no science. And so for these reasons, Your Honor, we don't think that Dr. Atchison should be allowed to parade this theory that it may have been this and it may have been that, and it's possible to the jury as a potential causation theory. Thank you, Your Honor.
Thank you. One quick point of clarification. We're asking to exclude him in his entirety, or
No, we're
just
just
certain
asking
opinions?
to exclude this opinion.
Okay.
He does have some other opinions that I don't really think go that far, but we are not asking to be excluded in the entirety.
Thank you. Just wanted that clarification. Counsel for Terrible Herbst, would you like to respond?
Good afternoon. I'm grateful that plaintiff's counsel addressed.
Please remember multiple people's state name on behalf of.
Yes,
I know
sorry.
that-
Trevor Everett on behalf of Terrible Herbst. I'm grateful that he ended with the Morsicato decision and the Williams decision. This is pretty. I mean, plaintiffs talk around the issue quite a bit. The Williams standard it modifies the Morsicato decision, specifically that when alternative causation theory is presented, it needs to be relevant and supported by competent medical research. Those are the two things when addressing an alternative causation argument. It is relevant and is supported by competent medical research. First, Dr. Cheesen's opinion is relevant. It cuts right at the heart of their causation argument. He specifically addresses their hydrazine argument, indicating that in the totality of circumstances, Mr. Hunwardsen had consistently consumed real water, both retail and 5-gallon jugs at great quantities up until the end of December 2019. He observed that. He observed his work. He observed his lifestyle. The one thing that was different was, which is in the record, that 2 weeks prior he started to consume concentrated cannabis. Now, what they don't address when they talk quite a bit about Nevada regulation is there's no evidence of where this concentrated cannabis was cultivated, purchased, made. There's no evidence indicating where it came from. So whether or not these stringent...
He wasn't asked? He wasn't asked where he bought it in deposition?
No, he talked about in his deposition hash that he had purchased and that he smoked with a bowl. Concentrated cannabis through dabbing is a totally different mechanism. You cannot use concentrated cannabis through a bowl. That's where you pack the marijuana, smoke it. Concentrated cannabis, you use a nail to heat it up and inhale through that mechanism. There's no evidence indicating where the concentrated cannabis came from. So of course, just in a garage. We don't know if he got it from his mom. We don't know if he got it from his dad. We don't know if he got it from his friend. We don't know if it was a black market dealer, which we know is a massive market since legalization. There's no evidence indicating where the concentrated cannabis came from. Again, his only requirement in this opinion is that it is relevant and that it's supported by competent medical research. Now, plaintiffs focus specifically on the Raber article, as discussed in our motion papers. His opinion is not solely confined to that one article. I have a list of the several arguments that he attaches to his opinion that he relies on. He also indicates that when these are tested from an unreliable source, whether it be an unreliable regulatory body or an unreliable person in a garage like they discussed, that there is an 80% chance in this study that what harmful substances, including solvents and pesticides, can remain in the product. These harmful substances, which Dr. Raber opines to, including, like they talked about, paclobutrazol, butane, and ethyl alcohol, are solvents that are known to cause acute liver failure. This is something that he testifies to. Again, Dr. Cheeson goes above and beyond that. He does testify to a reasonable degree of medical probability that his belief this did cause Mr. Hunwardsen's injury, even though that's not the standard he's held to when he's providing alternative causation opinion. So A few more things. And so when you address the two standards, all of the medical research that was relied upon by Dr. Cheese and the list that I have that was included in his opinion are all peer reviewed. Plaintiffs take no issue with the location or source of that. He has extensive experience in the field. He was a former FDA Associate Commissioner. He was the Chief Medical Officer of Public Health and Science at the Food and Safety Inspection Agency for the Department of Agriculture. He's a professor in molecular pathology and epidemiology in New England. He's been there for 12 years. He also, specialized throughout his career in medicine and infectious disease. He's qualified to discuss these topics. He understands what can cause and cannot cause acute liver failure. And what is more, he also relies on the information that's included in the record, specifically Dr. Gong's opinion, where she talks about the length of time one has to be exposed to the potential substance, a drug, or toxin that can cause acute liver failure. So to say that he's not relying on competent medical research is incorrect. Based off his experience, his education, his background, the literature that he looks at, and then whether or not it is relevant, those two questions are easily yes, it is relevant. It cuts at the heart of their causation argument. That whether or not hydrazine caused his liver failure, he is saying it did not. He is saying that concentrated cannabis, which the evidence in his research and throughout his experience shows can cause liver failure. The research that he relied on supports that and is relevant for those reasons. In addition to the fact that we do not know where the concentrated cannabis he consumed came from, the overseeing eye of Nevada regulation does not apply because we don't know if it was created here, if it was manufactured here, or if it was grown here, if it was sold here. So yes, whether or not it is a stringent system, whether or not it was done appropriately under their watchful eye, that doesn't matter for our purposes. What matters is that his testimony was relevant and it is supported by competent medical research. And for those reasons, we think his medical opinion should be allowed as far as causation goes.
Are you saying that he was asked and he couldn't tell you where it was, or he was never asked?
In his deposition, he was specifically asked if he had consumed marijuana. He said yes, quite frequently. His mother also says that he did. When asked what type of marijuana he consumed, he specifically talks about consuming marijuana. And he also asked him about his administration. How do you take it? I take it using a bowl. It's purchased at dispensaries. But hash that is at dispensaries, but hash that is smoked through a bowl is not concentrated cannabis. They are two separate products. So he did not ever say once in his deposition that he consumed marijuana through the administration process of dabbing. They're two. They're one. You have an edible. You can smoke it. You can dab. He only admits to smoking marijuana using a bowl. That is it. When he was asked specifically how you take it.
Okay, thank you so much.
And to further that, which is included in Dr. Cheesen's opinion, the record shows with his UCLA doctors that he did introduce concentrated cannabis into a system and started consuming it 2 weeks before his liver failure. So when Dr. Cheesen is reviewing the totality of circumstances, what changed in Mr. Hunwardsen's, what changed? He drank real water from 2016, year. 2019 hits. He has the same employment. He has the same activities, does the same things. What changes?
Say something different, though? I mean, don't you say in your other briefs that there is a difference because it was a difference between the Terrible Herbst bottle versus the 5-gallon jug?
Sorry, say that again. He consumed 5-gallon jugs prior as well.
Okay.
So he had home delivery. I mean, that's not in dispute. He started having home delivery after he enjoyed the product so much and was purchasing it often early on.
No worries. Okay.
And so he started having home delivery as well. Regardless, what changes in his life? 2 weeks before, he starts dabbing. There's competent medical research that shows that dabs, when it's unregulated, will end up possibly with certain solvents, which Dr. Cheesen specifically testifies to, and certain pesticides. And then also the administration, if it's heated too much, butane can be released, which there's other substances that can happen. That changes. And that is what is important. And that's why is a, it's an alternative causation argument. It goes right at the heart of plaintiff's theory.
Okay, I appreciate it. Thank you so very much. Counsel for plaintiff, you get last word.
Judge, I think a couple of your questions elucidated even more speculation. They don't even know what he used, where he got it. They didn't focus on that during discovery. This whole data thing seems to have been created after the fact. I mean, at least you should ask the plaintiff. At least you should make some kind of effort to find out what store you got it from. But they didn't do that. So, I mean, I think that's just more speculation. So now they're speculating that it must have been from an illegal source. They don't have any evidence of that. And then moving to the science aspect of it, he kept saying research relied upon. Well, he didn't tell you the name of one single paper. And the reason for that is because when I took Dr. Atchison's deposition, he had a couple of other papers talking about contamination of THC dabs. We went through them footnote by footnote, and he hadn't read them, so it made it a little difficult to do. But we went through those papers footnote by footnote, and every one of them goes back to this Raber paper. Raber is the only source for any discussion about the THC dabs potentially having pesticides or solvents, and I've already discussed that at length, Your Honor. So I think, I mean, I don't know what more to say than that this is pretty wild speculation, should be concluded.
Okay, appreciate it. Thank you so much, everyone, for the excellent briefing. The oral argument, the court's going to grant plaintiff's motion eliminating number one to preclude defendants from offering highly speculative opinions that a THC dab caused the acute liver injury of Hunwardsen. Realistically, it doesn't meet Hallmark. It doesn't meet Moscato. It doesn't meet Williams. Page 16 of the motion sets forth part of the testimony of the underlying potential expert on this, and he uses more possiblies and ifs, and not even knowing where things are purchased. Can't make an assumption that it's out in the fields somewhere and had some overflow from, I don't know, corn crops or something else. Maybe it was not organic next door. Realistically, folks, it does not show the links, does not meet science, does not show alternative causation. In fact, I was going to quote, one moment, please. Okay. Second, I was going to go to a quote. Even in their own, the brief, page 8, 9, although Dr. Atchison affirmatively testified that he only identified, and I'm not going to be able to pronounce this correctly, paclobutrazol, Paclobutrazol. I've never been able to pronounce that correctly, and I'm not doing it well today either. By name in his report, he also testified that, quote, in no way should that be taken as the only potential pesticide that could be used in the marijuana industry that may have liver toxicity. It's simply an example of one that was found as a recognized hepotoxin. And realistically, there's more ifs. Well, if may be terrific, if does not the standard of Hallmark, Moscato, or Williams, and so therefore the court has to grant the motion. It is so ordered. I am adopting the arguments and case law set forth in plaintiff's briefing. Thank you so very much. Taking full into consideration the opposition. Real Water, you didn't have an opposition, so I didn't ask you. Should I have asked you?
We have no position on that.
No worries. Okay, thank you so much. Moving on